Welcome. Wanted to share today a thing that happened in 2018. It was a resolution, Senate resolution known as NH 1778. It was actually submitted by a senator sitting in New Hampshire at the time to the New Hampshire Senate. And it was about the authority of the Department of Highway Safety, the Secretary of State, those that are responsible for licensing and registration and things on the public roadways. They cited a court case, they cited some law, and they talked about potentially some of the failings of the people, of the servants, if you will, public servants to the sovereign people. So we're going to take a look at that right quick. And we're going to break down the statement of purpose a little bit. We're going to look at the office of the sheriff. We'll take a look at the court case and the law that they pointed out, and show as well how something from New Hampshire can be ported over or made applicable for the particular state that you're located in. So in this particular instance, we're going to start with a statement of purpose. The general court finds the authority of the Department of Safety. The general court happens to be the New Hampshire Supreme Court in this situation, and they found that the authority of the Department of Safety is limited to commercial users of the public ways. So first, looking at what the Department of Safety means, we're talking about the Secretary of State here in Michigan, the DMV, or the locations or organizations that are responsible for automobile registration and driver licensing. The Sheriff's Office is a part of the Department of Safety, the State Police, the Highway Patrol, or the Municipal Police Departments. These are all members of the Department of Safety. And so their authority is limited to only the commercial users of the public roads or public ways. And so the commercial users would be the corporations, incorporations, sole proprietorships, and registered individuals. Another commercial term would be body or bodies politics, which would be governance organizations. A co-partnership is considered a commercial entity, so are associations. Business, in other words, whether it's for-profit, not-for-profit, non-profit, or government. These are considered corporate entities, legal entities. So, and that the corporate state employees have. So corporate state employees within the statement of purpose, and they do use that term, corporate state employees. They refer, of course, to the Department of Safety that we just looked at, the Secretary of State, the sheriffs, the police, and the state police. But it also would refer to the governor. The Attorney General is considered a corporate state employee. Judges, clerks, the prosecutor's office, all of the corporate state employees could be considered within this terminology right here. And so they further found that these corporate state employees have, by their silence, failed to fully inform the sovereign people of this state that an automobile has been confirmed by the Chief Justice by a court case in the court case 108 NH 386. And Justice Grimes was the one who made the statement. And the statement out of the court case was, since we were purchased for personal, family, or household purposes, the DART is classified as consumer goods. And he even quoted the law. So that's a direct quote out of the case. And in this particular situation, the DART refers to the Dodge Dart automobile. So because it was purchased for this type of function, it's considered a consumer good. So we're going to go ahead and take a look at that further. Here is the actual court case. I grabbed a copy of it and put it up here so you can see it. And here is that actual quote. You can find the same thing out there if you wanted to take a look at it yourself. So didn't make that up, there it is. And so Justice Grimes, in that case, considered it to be private property defined by RSA, Revised Statutes Annotated. 382 is the section in New Hampshire, and it was specifically A9109. And here is the code, and that is actually, for those that might recognize it, 9109 is out of the Uniform Commercial Code. And as far as I know, just about every state has it in the Union has adopted it. So there they use 382 and incorporated the UCC codification within their 382 section. So Here is a copy of that, just like I grabbed a copy of the court case. Here's a copy out of the 2006 New Hampshire statutes of that particular section. It gives you the scope, and here's how they label it. And then I took the opportunity as well to just change the color of a couple lines within it, like a transaction regardless of its form, or down here further, section 9-340 applies with respect. So you'll notice here's a claim arising. These points are highlighted right now and made red, just so you can see in the next slide here. I've gone and got a copy of it for Michigan. Act 174, 1962. Michigan uses 440 would be the compiled law section, and then they use the 9109 as well. So you can find the Uniform Commercial Code in Michigan under the 440 dot section, just like you can find the Uniform Commercial Code in New Hampshire under the 382 section. And again, you can see here's the red markings of a transaction regardless of its form. Here's section 9340 applies with respect, and here's a claim arising in tort. So Michigan has adopted the UCC. The language is the same. The only thing that changes from New Hampshire would be the codes and the things and the section that they applied to it within their own statutes or codification. So they determined that in that court case, based on that law, that your automobile is a household good and consumer good, not for a commercial use or for profit or gain, which means when you buy it for a consumable good, it is not intended to go out there and make you money in a commercial application. So to look that over quickly, the Supreme Court, starting in New Hampshire, finds that the authority of the Department of Safety is limited to only commercial users of the public ways, and that the corporate state employees have, by their silence, failed to fully inform the people of the state that an automobile has been confirmed to be private property defined by law as a household good and consumer goods, not for commercial use or for profit or gain. And then the court, so now that we understand what was said, then the actual resolution is put in by the senator, says further, the courts have found that the corporate public servants who ignore their accountability, and when they say accountability here, they're talking about accountability to the sovereign people, to the law, the constitutions, its bills and amendments, as well to their oath of office. If they took an oath of office to uphold the law on behalf of the people, well, then they are accountable to themselves for their oath. They're accountable and held under law, and that it is the people that they're also supposed to be accountable to. So the courts have found that the corporate public servants who ignore their accountability, and here they even put in as mandated in Article 8 of their New Hampshire Bill of Rights. Now, to take a look at it, their Bill of Rights even says that all power residing originally and being derived from the people, all the magistrates and officers of government, all officers of government are their substitutes and agents, and at all times accountable to them. So they are accountable, as they pointed out here, by law. They just listed a specific law, but they're accountable to many other things as well. But first and foremost, it's to the people. And so they have, by their silence and failure to fully inform the people of the consequences arising from the corporate offer to contract. The offer is to be a commercial entity, a legal entity, to participate in the public roadways, on the public ways, in a commercial capacity, which again would require some form of licensing. So by their silence and failure to inform the people of the consequence in what they're offering as a service to the people, they have basically committed silent deception and an inducement by fraud. This is literally written in that NH 1778 as submitted by the senator. So he's pretty much calling out all the public employees for remaining silent and allowing people to register in a commercial capacity when ultimately it is household goods and consumer goods that the people intend to use their product or their automobile for. And most people are familiar that fraud vitiates all contracts. So if this really is an offer to contract, and through their silence they have induced you into the contract, and that's fraud, well then those things are all void, voidable, or null, as if they didn't exist. So we're going to look at the sheriff's duties now: road patrol and monitoring, accident response and investigations, enforce criminal laws of the state. The sheriff also has to recover bodies that drown. They have to maintain a jail and court processes. So in Michigan, the constitutional office of the sheriff is created in the Constitution, but it says in the Constitution that their duties are prescribed by law. And in Michigan, we find that in Chapter 51, where basically there's over 300 separate statutes that empower and restrict the sheriff within each county. And so specific duties listed include patrolling the roads, enforcing state law. Enforcing state law is listed in there next to patrolling roads. Investigating traffic accidents for people on or near the highway. Enforcing criminal laws of the state, violations which are observed by or brought to the attention of the sheriff while providing patrolling and monitoring required by the subsection. Well, the sheriff also has a responsibility when a citizen or a member of the county comes to the sheriff and makes a claim that somebody has violated the law in a criminal way, then the sheriff's also got a duty to open a complaint and do an investigation. So they are supposed to investigate various things there. The sheriff is also required by statute to keep a jail. They shall have charge and custody of the jails in their county. Sheriff is designated as the person responsible for the service of all court process. If the court needs a process carried out, then it is the sheriff who's supposed to carry forward the service of the court. Statutes demonstrate the duties of the sheriff are immense. Again, patrolling roads, searching out criminal law violators, traffic violators. Those are listed separately for a reason. Investigating accidents, recovering drowning victims, keeping a jail, and many other duties. They also have the responsibility of patrolling the waters of streams, lakes, and rivers, patrolling snowmobile and ORV trails. They also participate in educational programs, community correctional programs, liaison programs in mental health and social services. They provide many emergency services. And so if the corporate public servants who are ignoring their accountability to the law or to their oath of office or to the people as they are mandated to be accountable, if they're continuing to do this, it should create some questions for us and some concerns in light of such definitive findings like court cases and laws as illustrated and detailed by the senator, or as you can see within the laws themselves. So one of those questions should be, is this deception and fraud a violation of criminal law? Is it civil law or is it criminal? Would it be criminal is fraud a criminal charge? So would the members of the Department of Safety, any of those areas of Department of Safety, the Secretary of State's office, the police, or the sheriff, would they be conspirators, accomplices, or the original perpetrators? Or would they be some form of combination of these types of actions as conspiratorial or as an accomplice or an original perpetrator? What crimes are committed should be a question that should come up in detaining one of the people under this deception and fraud. What crimes are committed in arresting one of the people that is actually just trying to get their groceries, a non-commercial user, under this deception and fraud? Arresting somebody and the stigma of going to jail and having handcuffs put on you is a different scenario and a different situation than just detaining somebody. So what crimes are committed in arresting one of the people under this deception and fraud? What crimes are committed in charging one of the people under this deception and fraud? Charging is to put you on the books and create a debt that you have to pay to society. It is a commercial term. And if you're a non-commercial user of the roadway, what crime is committed in making it a commercial transaction by charging you and putting you on the books for a debt under this deception and fraud? What crimes are committed in dispossessing one of the people under this deception and fraud? Is it a crime to take somebody's property away from them under this deception and fraud, take their car, take other rights of locomotion and things of that nature away? What crimes are being committed in the way of dispossessing, charging, arresting, or detaining? What crimes are committed above and beyond these? These are just a few of the crimes that you might think of that could be happening under this deception and fraud. What other crimes might also be happening under this situation? Now, another question that we should all be asking ourselves is, who is subject to arrest for violating criminal law? Wouldn't the answer be any violator or any suspect? Anybody who is suspected of violating criminal law? Aren't they due for their day in court? And shouldn't they be arrested for violating criminal laws? Wouldn't it be violators or alleged violators? So the next question is who is required to arrest a violator of criminal law? Well, we just read in the last duties and responsibilities of the sheriff that the sheriff is responsible for enforcing all criminal laws and investigating criminal law. So if the sheriff is required to arrest the violators of criminal law, and it is the public servants who are basically committing fraud and silent inducement into contracts, which is considered a fraud, wouldn't it be a sheriff that would be responsible for arresting these Department of Safety employees? And many people have been calling out for these arrests, and some sheriffs have been unwilling at this point in time to carry forward their common law responsibility of arresting criminal law violators. So now that we've taken a look through the office of the sheriff, as well as the New Hampshire resolution, we saw a copy of the law from the New Hampshire statutes. We also saw a copy of the Michigan law. What we're missing at this point in time would be a look into a court case in Michigan. See that in each state, the state has their own Supreme Court, and they are bound by the rulings of the Supreme Court or the courts below and lower and lower and lower. So a court case from New Hampshire doesn't help all that much here in Michigan. So just as we looked up the law in New Hampshire and found that there's a Michigan law that is the same exact thing, we try to do the same thing when it comes to the courts, so you can have a strong argument in case you have to enter a court's jurisdiction. So here in Michigan, I guess first of all, you'll notice that I use Scholar Google, where you can enter in terms like consumer and goods and vehicle. And in doing a search there on Scholar Google, I eventually came across the Zine versus Chrysler Corporation case. It came through in 1999 at the Michigan Court of Appeals. And here they actually looked at whether the use was for business or personal use under the Michigan Consumer Protection Act. Now, the Michigan MCPA, Michigan Consumer Protection Act, is where you might find the lemon law. So if somebody sells you a bad product, as a consumer, you're supposed to be protected. And so in this particular case with Zine, Zine got a product from Chrysler, and he felt that under the lemon law, he needed protection from the state, so he sued Chrysler. And so they get into the MCPA and what it means and how it's used. And in so doing, they had to go through specific things like defining the term trade or commerce as under the MCPA. And here they said it was the conduct of a business providing goods, property, or services primarily for personal, family, or household purposes. So the intent of the act is to protect consumers in their purchases of goods, which are primarily used for personal, family, or household purposes. And that's according to this particular court case, which you can go ahead and follow if you wanted to do that. Now, as the court began to deal with Zine versus Chrysler, they had found that there had been prior rulings in a case called Catallo. And in Catallo, they basically noticed that, or upheld, that it was who bought it that mattered, not what they bought the automobile for. So in Catallo, it was because a business bought it that made it subject to registration because it was believed to be for commercial use. And so in Zine, they went back through and said, wait a minute, perhaps it isn't what buys the automobile, but what the intent and use of the automobile is, would be more controlling and a better control as to the aspect of whether it remains a consumer good or whether it becomes a commercial asset. So in Catalo, they actually have to get through dealing with the word personal, which means it relates to a particular person. And then the MCPA actually defines the person as a person. So that doesn't say anything. And natural doesn't have any definition either. So the only thing we're left with really is a corporation, a trust, a partnership, incorporated or unincorporated association, or other legal entity. We're talking about legal entities created by the legal system, not created by a mom and a dad. So here the MCL that covers the MCPA, compiled law that covers the MCPA, and that definition is 445902C, which is also in the Michigan statutes annotated here. Now, what's interesting here is that this court, the courts in Michigan, has ruled that office furnishings, we're talking about furnishings, furniture, sold to a business for its own use in its own office, were primarily for personal use. So it's a business that has a person because it's using it for its own personal use. So that fits quite a bit with legal entities under partnerships, corporations, and unincorporated associations, and that was within this court case. So they got down further and they said person is used in the MCPA in reference to those bringing acts. So they get in further and further in defining persons serves a broader purpose and versus personal. So Catalo was eventually pretty much overturned or modified here in Zine. And so what they did here is they ended up saying that it wasn't that a person bought it, it was what it was going to be used for that made the difference. So here, Zine again was looking for protection as a consumable good, but he testified that he's self-employed as a sales rep. He bought the truck for his business and primarily for his business. He described it as a business asset. He had a cargo box installed. He had a hydraulic lift installed. He had the name of his company painted on the side of the truck, but he also added that it was also for his personal needs, like going to the grocery store, post office, or carting his two sons around. But he said that 80% of the mileage that he put on the trucks were attributable to business. And he also admitted that he claimed a business deduction for the depreciation of the vehicle. So he was using the vehicle pretty much for business and writing it off as business and rarely using it as his personal transportation. So the court came through and basically said here, we conclude that reasonable minds could not differ in concluding that Zine purchased the truck primarily for business rather than personal use. So because you look at it and you read it and you understand it, what he said he was using it for, he would say that pretty much anybody with a brain would figure out that Zine purchased the truck for business rather than personal use. So therefore, Chrysler, who had claimed that it was no longer protected under the CPA because it was no longer a consumer good being used for carting his kids around and going to get groceries, it could no longer be considered a consumable good or private property, thus not subject to commercial application. And so they granted Chrysler standing for their argument that Zine had bought the vehicle or automobile to use for commercial application. So he did not win, but he specifically brought forward the argument, and the courts in Michigan, just like in the courts in New Hampshire, they were able to contemplate and realize that it's what you buy the automobile for and how you intend to use it, not whether or not it was a man, woman, person, business, corporate entity that bought it that made the difference. It was how the actual good was being used. So that made a large difference, and it should make a large difference going forward. Hopefully, Now that we've got through this a little bit, you got a little bit of understanding why some people are starting to travel and move around on the roadways under their right of locomotion with a private plate on the back of their automobile instead of having a commercial plate through registering the automobile with the state and getting a plate from the state. And this should hopefully also show you how to find something in one law, like New Hampshire's law had the Uniform Commercial Code adopted, and then being able to look for that same type of thing in your own state. So you can find your own applicable laws in your own state instead of trying to apply another jurisdiction to your situation. Hopefully the Google Scholar here showed you the same type of situation to where you find a court case in another state from another court. You can go ahead and begin to look using tools like Scholar Google here at finding court cases within the jurisdiction that you might encounter. So I hope this helped in understanding a little bit of the difference between what you're using your automobile for and how that makes a difference as to whether or not it should be taxable as a commercial good, i.e. registered and brought into the state, or whether or not it is appropriate to have it not taxed as the senator had proposed in 1778 resolution there in New Hampshire. Hope to get a few more of these done in the next few days. Thanks for joining. Bye for now.